Can you restate your argument about jurisdiction insofar as you suggested that Gertz retains a common law authority despite any ruling of the court? That sounds an awful lot like you're saying that if the federal court were to decide that Mr. Reed wins under Article 64, or otherwise his procedural due process claim, Gertz could say, I don't care, I'm not going to give it to him. So can you help me understand what you mean by this?
Certainly, Your Honor. As Mr. Reed acknowledged in her argument, there's essentially two different, entirely separate avenues by which a prisoner in Texas can seek DNA testing. One is by agreement with a prosecutor. Article 64 does not bind that in any way. It does not cabin a prosecutor's discretion whether to issue DNA testing. It does not impose any requirements on a prosecutor. It's essentially a plenary common law privilege that the Court of Criminal Appeals has recognized. Chapter 64 governs how individuals seeking through motions in Chapter 64 seek DNA through the court system. It's an elaborate procedure that once it's begun, an individual who has such relevant DNA evidence has to surrender it.
All right, so what happens if the person seeks DNA testing under Chapter 64 through the courts, and the courts decide that the person wins? They get DNA testing. Are you suggesting that the prosecutor's independent common law authority could somehow override that, and the prosecutor could say, I disagree with the court and I'm not going to give it to you?
Absolutely not, Your Honor. Texas law, of course, provides that individuals who've brought Chapter 64 motions, individuals with relevant DNA, have to deposit that with the court. The court would issue an order providing for DNA testing on its own, and that order would go off to whoever the custodian was, and that would be followed.
All right, so if your point is that we have a jurisdictional problem in this case because Mr. Reed has named Gertz, and Gertz would only have authority over this under his common law principles, why isn't the answer just let him amend the complaint to sue the relevant person? I mean, that's sort of what happens. It's not that we say no standing and we dismiss the case ordinarily. A child court would say, oh, you have a problem because you've named the wrong official. Let's just allow for substitution. So why isn't that the answer?
Certainly, Your Honor, in part because he'd ultimately, no matter what, have a problem under Ex parte Young. As this court put in Whole Women's Health, the plurality joined by Justice Thomas, the requirements for Article 3 standing in Ex parte Young for getting around the sovereign immunity of, for example, the Court of Criminal Appeals requires something like an immediate or impending enforcement action. There is no such enforcement
Okay, but that's
action.
just an argument that Article 64 can't, the right that is given can't be enforced, because to the extent that the court is the one that would hold the evidence, and under Article 64, you, as a prisoner, come to the court and you invoked that provision, but it's the court that holds it, and under Ex parte Young, you can't really sue the court. You're just saying that's a no right. And I don't understand how the law would be constructed in that way.
Respectfully, I disagree, Your Honor, for two reasons. The more important one being that the petition that Mr. Reed sought under Section 1257 to this court was a proper vehicle for alleging a due process problem in the Court of Criminal Appeals. He, as a matter of fact, in that petition raises substantively identical due process challenges as he raises.
So you're saying there's no 1983 claim that can be brought to enforce an Article 64 right?
At least not like this, Your Honor. And we agree that that's inconsistent with the exercise of jurisdiction this court impliedly allowed in Skinner. As this court has put in Steele Co., though, those sorts of questions that are neither passed upon or briefed.
No, not impliedly right. That was the basis of the Skinner Rooker-Feldman analysis. I mean, isn't that what the court said? And in Osborne, you can bring this kind of claim in federal court. Says this court in Osborne and Skinner. No?
2 points, Your Honor. First, as this court puts in Steele Co., essentially implied exercises or blessings of jurisdiction that are not actually made holdings of the court don't bind the court going forward. Now, the court did make a jurisdictional determination regarding Rooker-Feldman that I think actually is important in this case also, because the court determined in its opinion, specifically relying on a concession that's not been made by Mr. Reed, specifically that his claim was not challenging anything that either the prosecutor did or that the Court of Criminal Appeals did. Mr. Reed has already indicated in his response to Justice Barrett that his claim does, in fact, challenge certain aspects of how the Court of Criminal Appeals reached its decision-making. So even on the narrow Rooker-Feldman point, Skinner doesn't
find... All right,
but
what about the Osborne point that seemed to preserve the ability to bring a 1983 claim that raised procedural due process concerns? And you're saying here that there really is no way for Mr. Reed to bring such a claim in this circumstance. So isn't that inconsistent with what I guess you're saying the court implicitly held in Osborne, but that was sort of the basis of the court's constitutional analysis in this case?
It's certainly inconsistent, Your Honor. The reason why we're not calling for Skinner to be overruled on this point is because this court has said specifically it is not bound by those, as Justice Scalia colorfully put it, drive-by jurisdictional analyses. But we agree that this is inconsistent beforehand. Nonetheless, even if this court were to essentially bless the exercise of jurisdiction asserted in Skinner and to continue from the merits, Reed should nonetheless fail on the merits because for several reasons. Mr. Chief Justice, one important concern you highlighted was the practical concerns about essentially everyone else. Mr. Reed's rule, which as far as we can discern today involves that his claim accrues as soon as he chooses to stop litigating in the state court system and neither a moment before nor a moment later, does a profound disservice to the typical DNA applicant who is not fighting off a capital sentence, who has been accused and convicted of a crime, and who wants one of two things: either resort to a constitutionally sound system that does not violate due process, or resort to a federal forum as soon as possible. Now, while he says now that his claim might have existed as soon as he exited the federal forum, of course, he claimed on page 17 of his brief that his claim didn't even exist yet until he had exhausted going through the state appellate process at minimum. So that's an important shift that he's made. I think, Justice Alito, when you pointed out inquiring whether or not a person would have a claim if, for example, the prosecutor said, well, I understand my authority to run coterminously with Chapter 64, and the Court of Criminal Appeals has said thus and such, certainly the claim accrues then because he's suffered a denial based on that unconstitutional condition. Another point, of course, is ours is an incredibly easy to administer rule. Because a Skinner claim arises essentially from a judicial decision in essentially all postures, every judicial decision has a file stamp date. Someone running a Skinner claim or making a Skinner claim is going to point to a condition that they say, this is the thing that violates due process.
But easy to administer or no, what's the point? If he goes to federal court pursuant to your rule while he's in state court, the federal court will just stay the action until the state court action concludes. So what difference does it make? I don't know. I thought the most compelling part of Mr. Reed's merits claim or argument was that none of the purposes of the statutes of limitations, the principles behind that doctrine, obtain in your rule. That it doesn't matter whether or not, other than just to keep a prisoner from ultimately being able to bring a federal claim.
Quite the opposite, Your Honor. In the ordinary case, our rule serves most individuals who want to be able to bring those federal claims. Recall that Mr. Reed's rule requires them to go through the state appellate system before, in fact, or at least the rule he advocated for in his brief, before they have a claim accrue. Someone like that, a person who is suffering under a term of years sentence.
The statute of limitations is not about the person who's bringing the claim. It's about the defendant, right? So the purposes that I'm trying to focus in on are the traditional purposes of a statute of limitations which protects the defendant. So why is the defendant in any different position? Not the person who's bringing the claim, but the defendant, the state, if we run the rule your way versus Mr. Reed's way?
Let me answer your question, and let me explain why I believe that's tied to accrual even on the plaintiff's side. The answer to the question is, of course, states are best served by having defined dates that are not manipulable by individuals who are seeking to extend the length of their claims as long as possible. Every statute of limitations is, on some level, a statute of repose that gives someone who's exposed to potential tort claims or other claims definition as to when they no longer have to be on essentially preparing for litigation for those things. Now, the flip side of that is an accrual rule typically marks when an individual may first bring suit. I heard though this court discussed the possibility of there being a claim that could be brought but that has not yet accrued. That is a very strange possibility. So when we're talking about an accrual rule that happens sooner in time, it serves state interests by giving states defined earlier and faster knowledge about what kind of essentially what claims are against it. It also serves plaintiffs because once their claims accrue, they have resort to a federal forum. So an individual who has to labor underneath Mr. Reed's rule, where claims do not accrue at least until the end of the appellate process.
There's no exhaustion, so he's still fine. There's no exhaustion requirement, so he can. Do you disagree with the representation that he can go to federal court at any time in this world?
I agree that he may go to federal court as soon as he has suffered essentially the due process violation, but I would point out that's inconsistent with what he briefed to this court.
But no accrual date keeps him from going to federal court, right?
If his claim hasn't accrued, Your Honor, at least as this court suggested in Madonna, a claim that hasn't accrued can't be brought. An individual cannot bring a claim that has not yet accrued. An individual could say, well, your claim isn't ripe yet for one reason or another. It hasn't yet accrued. That is the function of an accrual date from a plaintiff's side.
On a statute of limitations.
Yes, Your Honor. If a claim is not yet accrued, ordinarily an individual can't bring it at all.
Justice Jackson?
Yes. So, Mr. Clement, I've heard you say several times in various ways that you think the regulatory scheme is about ensuring a minimum amount and not the weekly guarantee, sort of hand-waving the idea of weekly guarantee. And I want to posit something quickly and then ask you about a hypo. I want to posit that 602 in the salary basis is actually parallel to 604 in that they're both ensuring the minimum weekly amount. Under 602, you get it in the form of a salary, predetermined, coming to you no matter how much you work. Under 604, if your setup is not that, if you're not set up predetermined amount coming in weekly, the regulation guarantees that you still have this minimum weekly amount through 604. All right, that's how I see it. And let me tell you why I think it matters. Because the regularity of a predetermined amount is how people pay mortgages. So I don't know, or it doesn't really matter that he might get $100,000 over the course of the year. What he has to know is how much is coming in at a regular clip so that he can get a babysitter, so that he can hire a nanny, so that he can pay his mortgage. It's about, I think, the predictability and the regularity of payment. So let me ask you this hypothetical. We have a nurse who does the covered functions and makes $455 for a 12-hour shift. That's about $38 an hour. Some weeks, this nurse is called in for one shift and makes the $455. Some weeks, he's called in for 4 shifts and makes $1,820. He doesn't know, because of the way his situation is set up, he doesn't know from week to week how much he's going to make. It just depends on how many shifts his supervisor asks him to work, and all that's guaranteed is at least one shift, right, for the predetermined amount of $455. So some weeks he makes that, some weeks he makes more. But if he doesn't work any shift, he doesn't get anything. I think that under your theory, as you've articulated it, he would be a salary basis worker and would not be entitled to overtime for the weeks that he does the 4 or 5 shifts. Am I right about that in terms of how you have set this up?
So I think you're basically right, but can I just add a couple of thoughts to that? One is, the statute doesn't talk about whether you're a salary basis worker, at least not 601.
I know, I'm talking about the regulation. We're setting aside for the moment the statute.
If I said the statute, yes. I misspoke. The regs don't care that you're a salary basis worker. They care, 601 in particular cares that your total compensation includes $455 per week paid on a salary basis. So I actually agree with you that the thrust of 604 is to ensure that there is a certain regularity of the minimum amount that you are guaranteed to make every week.
Wait, I'm sorry. How could you say that 601 doesn't care if you're a salary worker? What is the meaning of paid on a salary basis? If it didn't care, it would just say your total amount of compensation must include at least $455 a week. But it then includes the words paid on a salary basis, and 602 tells us that being paid on a salary basis means a predetermined regular amount.
I think the only disconnect is when you, I don't think it cares whether you're a salaried worker, because when I hear salaried worker, I think, well, that must mean that's where you get most of your pay. All it cares about is whether you are paid at least $455 a week, paid on a salary basis. And those are different things, because
I'm sorry, so if I'm a light bulb, so you're saying the minimum amount has to be the regular thing coming in?
Exactly.
All right.
Exactly.
But how does that solve for my problem in terms of understanding that the agency and to some extent Congress could care about the variability that keeps people from being able to do other things in their lives, pay a mortgage or whatever? Like, it matters whether you are in a situation in which you're only paid for the amount that you actually work versus you know that you have a predetermined weekly amount coming in.
I think what matters for paying your mortgage and most other things is what's the minimum you're going to have guaranteed coming in. It's not whether you make if you got an $800 mortgage
on the
payment.
Size of your mortgage,
yeah,
right?
Right. But here's the thing. I mean, I do think Congress cares and the regs care about the minimum. So you can make your $800 mortgage payment with your $963 guarantee. But it's very clear that 601 for the highly compensated workers doesn't care about the variability of your total annual compensation. And one of the reasons is the catch-up payment. It says you can have a catch-up payment. It can be a huge catch-up payment at the end of the year. And it creates sort of a safe harbor. So somebody that they thought was going to make $100,000, but they had a bad year, they're only making $50,000. They can have a big payment at the end of the year. That's not consistent with a concern about stability on the top line. It is still consistent that you get at least $455 every week paid on a salary basis.
Thank you, Justice Jackson.
Can I just quickly return to Justice Alito's hypothetical, which I think is a little bit helpful in trying to pinpoint a problem that I've been having. It seems from the race hypothetical that if there was only one basis for giving someone a boost, and that basis was race, then I see disadvantage absolutely to anyone else who's not an underrepresented minority who can get that boost. But I understood that we have here a program in which there are at least 40 different bases for being able to get a boost. And not everybody who is an underrepresented minority gets a boost. So it's really hard to figure out if anyone is being disadvantaged in a system like that. And that's where I was worried about standing, because I'm trying to understand how the system is operating to actually advantage minorities in a way that is harmful to anyone else in this system.
Yeah, and I think that attributes to the careful cue that UNC has taken to this court's decisions in Fisher 2, making sure universities find themselves in this Goldilocks problem about considering it too much or too little. The university.
But there are other considerations, is the point. Everyone can get a boost for all sorts of reasons. Minorities don't automatically get a boost under this system, so it's hard to know whether anyone's being disadvantaged from the mere fact that a minority could get a boost in this environment, right?
That's right. And the evidence also bears it out at Petition Appendix 78, where the evidence showed that hundreds of white students with lower combined GPAs and SAT scores were admitted ahead of higher performing Black students, Latinx students who went to UNC. And I think that bears the hallmark of the type of individualized consideration that this court wanted.
But Mr. Clement, why doesn't whether or not it's wholly collateral turn to some extent on the remedy that you're asking for? It would seem to me that one way to think about the collateralness of this is whether, when you're done with it, the claim that you want to bring in district court, you would go back to the agency and the agency would proceed. I think that in a situation in which you have the type of claim, maybe some of your removal claims with respect to the ALJ, for example, if the remedy is just give us a new ALJ, then there's a concern that what is happening by allowing citizens to go to the district court is that they're sort of superintending the agency process. Whereas you could say, and therefore you could say it's not wholly collateral in the same way as if you went over and the remedy was to terminate the agency process. So why shouldn't we be thinking about the collateral nature of this based on the remedy that you're asking for?
So two things, Justice Jackson. First of all, I think the most sort of straightforward way to think about whether it's wholly collateral is, does it turn on the facts of the particular case, or is it a claim that would be the same no matter what the facts of the particular transaction is or the particular immigration circumstances of an individual? And if it really doesn't matter on your circumstances, then I think it's wholly collateral. To your point about the remedy, though, I think that favors us, especially on the removal claim, because I think the problem is there are cases where the remedy you want is really just to have your federal job back or the Mine Safety Board order vacated. And in those situations, maybe it makes sense to say, yeah, if you're in the process, it leads to an order, and at the end of the order, you can get it vacated. That's good enough. That's a meaningful judicial remedy.
But I guess maybe I'm not so clear. I meant a remedy that does not have you returning to the agency in any respect, so that your claim is such that, you know, the core constitutional claim, this agency doesn't have power over me, you can go to the district court because if you win, then the agency is done. What I'm concerned about is the interpretation that allows you to take certain claims over to the district court and have it impact the agency, ongoing agency proceeding in a way that makes it unclear that that's what Congress intended in terms of saving 1331.
So I guess I would just amend your observation. I mean, I think you're right that if you have a remedy that says I ought to be completely immune from this agency's actions at all, that's something that does seem like it should be able to go forward in district court. But I think if you have a claim that's effectively, I shouldn't be in front of this agency at all as currently structured, that is equally a claim that doesn't belong in front of the agency. And I think, as I indicated to Justice Thomas, I think it's particularly clear when you start thinking about the right remedy for the double for-cause removal restriction here. Now, obviously, you could remedy a double for-cause removal restriction by invalidating either layer of removal. But if a court were to follow the pattern of Free Enterprise Fund, you'd get rid of the second layer of removal restrictions, and those are in 5 U.S.C. 7521.
Mr. Fagan, that's not how it works. I mean, the fact that it might map on to another theory of fraud isn't sufficient in a criminal case, because doesn't the jury have to be actually instructed concerning the other theory? What worries me is the thought that the jury was instructed, and Justice Sotomayor just read the instruction. The jury was instructed on this right to control theory, and they convicted on that theory. If we determine that that theory is not consistent with the law in some way, I don't know that we can look at the evidence that was presented, especially given the fact that, as Mr. Dreeben says, the evidence was presented tailored to that theory. But even so, you seem to be suggesting that we can go back now and look at the evidence that was presented and say, oh, but there was enough for another theory that the jury wasn't instructed on, and so we can sustain the conviction on that basis.
Well, 2 points, Your Honor. One, as the case comes to this court, and without prejudice to whether they may have preserved the other challenges below, as the case comes to this court, it's just a pure sufficiency of the evidence challenge. And what that looks at is, here are the elements of the statute properly construed, and here are the facts of the case, and do they map on to each other?
Wait, how can you say that when they have charged throughout that the actual law that was being instructed was invalid?
So if what the court wants to say is that the jury instructions were in fact invalid, I think they forfeited a challenge like that at right at the beginning of their petition cert stage reply brief. But again, the court could send this case back to the Second Circuit to sort out where we are now. But our submission in this court, and the reason we think this court can affirm, is that if the jury instructions could be characterized as essentially just misdescribing the elements of the crime, but in a way that wouldn't have allowed for the jury to find guilt without finding the properly understood from first principles elements of the crime, I don't think that the defendant has been deprived of anything. They point to evidence they would have introduced, but if you look at page 1002 of the Court of Appeals appendix, the district court judge made clear, I'm sorry, Your Honor.
Finish.
The district court made clear that it was open to evidence that Simonelli actually could have done this better than anybody else. What it wasn't open to was evidence that Simonelli just gave it a quid pro quo, which is exactly the kind of thing that we don't think fits even under traditional property concepts. Thank you, Mr. Chief Justice.
With respect, the assets that the Second Circuit pointed to were not the assets that the government now seems to be wanting to have this court recognize with respect to the right to control theory. I'm looking at the actual opinion in this case where I guess it was Judge Chen maybe wrote the opinion in the Second Circuit, and it says this court has endorsed a right to control theory of wire fraud that allows for conviction on a showing that the defendant, through the withholding or inaccurate reporting of information that could impact on economic decisions, deprived some person or entity of potentially valuable economic information. So it seems as though the asset that the Second Circuit was focused on was potentially valuable economic information. Am I wrong that that's what they thought the right to control theory was about?
Well, Your Honor, I think if one looks at the entire opinion, which I know we all have, it's hard to come away from that. I mean, maybe you can pick out a specific sentence, but it's hard to come away from the opinion with any impression that the Second Circuit thought this case was about something fundamentally different than what I described.
But you're describing the asset as the actual contract, as the money that was tendered in this transaction. And I didn't understand that to be what the right to control theory was about from the Second Circuit's perspective. So I guess I just don't understand. It seems as though you have reinterpreted right to control to be the new theory of fraudulent inducement in a way that the Second Circuit did not seem to put that theory forward, and that's what we thought we were taking in the context of this question presented.
Well, Your Honor, I fully acknowledge that we're not thinking about this the same way as the Second Circuit, and for the reasons I was explaining to Justice Thomas, we do think the Second Circuit has developed a way of thinking about this that puts everything in the property element that's not the right way.
And Mr. Dreeben says that's the way you argued the case below. So suddenly now we're at this stage with a reinterpretation by the government of what right to control means. And why isn't that a sort of a forfeiture from the standpoint of if the court disagrees with you that right to control equals this transaction, or even if we don't, haven't you put forward a case that was based on the Second Circuit's conception? And that's how it was argued to the jury. That's how the jury decided it. So why isn't Mr. Dreeben right that if we disagree with that conception of the theory, then we have to reverse?
Well, Your Honor, the jury was instructed on the language of right to control assets, and both the jury's instructions and deliberations, as well as the Second Circuit's consideration of the case, occurred against a backdrop factual context where everyone understood the undisputed fact that what was really at issue here were lucrative government contracts. And that's why the Second Circuit goes on to reject the idea that there's any dichotomy between the bid rigging process and the award of the actual contracts. If the theory were as broad as the sentence that Your Honor read suggested, there'd really be no need to do that because you deprived it of economic information simply by rigging the bid rigging process. Instead, the court makes clear, and this is at footnote 9 on page 22A of the petition appendix, that one of the reasons why this is fraud is because it was an essential element to the bargain, which I think maps directly onto what materiality would require in this context. And that's because it was incorporated into the notice to proceed that the parties entered into, which is a contract that committed LP Simonelli to spend $3 million in funds and the state to repay those funds. And then the notice to proceed was later incorporated into the final contract itself. Those are at Joint Appendix 125 and 134, respectively. So I think in the particular context of this case and fraudulent inducement cases generally, there's not going to be a lot of argument over whether there is underlying property at issue. I think where the Second Circuit's theory is problematic is both, as I said, in moving what really is part of the materiality inquiry in the particular context of contracting and moving that into the property element, and then potentially outside the context of fraudulent inducement cases, you could get circumstances where the Second Circuit's theory could be applied too broadly if you take loosely language like Justice Jackson appropriately just pointed out. So we don't object if what the court wants to do, and frankly what we'd urge the court to do, is to explain that the Second Circuit may not be thinking about this in the most precise way, in the most traditional way. What we would very much object to is something that suddenly erects the harm requirement that the court firmly dispensed with in Shaw, where it not only rejected the harm requirement in that case, it adopted Judge Learned Hand's formulation that fraud can exist even where there's a quid pro quo. It pointed to Carpenter as an example of not requiring harm, and Carpenter is a case in which the victim, the Wall Street Journal, wasn't economically harmed at all. And third, it actually definitively resolves the false pretenses debate that petitioner wants to have once again when it interprets false pretenses not to require this kind of harm. And if you want to look at examples of how the kind of thing I described as pedigree fraud was covered at common law, I'd encourage the court to look at some of the turn-of-the-century cases at pages 753 to 754 of the Prosser treatise, which is cited in our brief. One of those cases, Hedden against Griffin, is a case by the Supreme Judicial Court of Massachusetts at a time when I believe Justice Holmes was on that court, although he didn't write the opinion. And in that case, the victim was tricked by the defendant into thinking that a bunch of his friends had bought a particular type of insurance, and in fact, they liked it so much they didn't quite buy the company, but they became members of the board of directors of the company. He himself bought the insurance, realized he'd been tricked, and the court acknowledged it was a perfectly valid insurance policy. He just didn't want it anymore because now he'd been tricked. It wasn't what he actually wanted. He was really depending, and it was an essential element to him, that the friends have bought it and that the friends were on the board of directors. And the only measure of damages in that case was the small premium that he had already paid. And he got a full refund and a rescission remedy. There are other examples of it, like the cases at page 19 and 20 of our brief, where, for example, there's a misrepresentation to a buyer that a family member wanted the buyer to buy this particular item. That is not harm in a property interest, or if petitioner would recharacterize it as such, I really think that we're slicing the conceptual bologna so thinly that it's transparent.
Justice Jackson?
Yes. As you might imagine, I would like to circle back to the concerns that the Chief Justice and Justice Kavanaugh raised about vacatur and the argument that you're making in this case. And
seems to be a kind of D.C. Circuit cartel.
it is. And in particular, the conceptual problem that I'm having with your argument. You point to text, context, and history, and I understand those things. But ordinarily, there's a symmetry between the claim that is being made in a case and the remedy that is provided to a successful plaintiff. And your remedy, the way that you're reading this, actually creates a disconnect for me. Here's what I mean. It is clear that the claim under the APA is about the manner in which the agency has exercised its discretion. And we know that agencies have no inherent authority. They get all of their power to make valid and legally binding policies from Congress. And Congress has said in the APA that in order to make valid and legally binding policies, agencies have to follow certain procedures. So when a plaintiff is making a claim under the APA, they're complaining about the agency's failure to follow the procedures that are necessary in order to reach a valid and legally binding result. Given that that's the case, I think there's a disconnect to say that the successful plaintiff only gets a remedy that is about the application of that rule to them, because their complaint is not about the application. Their complaint is that the agency did not have the authority to do what it did because it didn't follow the procedures under the APA. It's as though they're saying what the agency did is void, it's a null set, because they did not follow the procedures that Congress required. So I just don't even understand. Setting aside how you read the statute to get to that result, it seems to me to not make sense to say that the remedy is to allow the agency to apply its void, defective rule to anyone else who's not the plaintiff.
So, Justice Jackson, I think where I disagree with your analysis is in suggesting that a plaintiff in a case isn't protesting the application of the invalid agency regulation to that party. That's the very nature of this kind of dispute. Now, it might be the case that the arguments they're making
but
about
I'm sorry,
why—
it's not the nature, because, I mean, obviously they are saying it was applied to them as a matter of standing. You have to have it applied to you in order to make the charge. But the claim is that the agency has failed to have notice and comment where it was required, or the agency has engaged in arbitrary and capricious decision-making. And if that's true, what it means is that the agency does not have a valid exercise of its discretion per Congress's requirements. The result, then, is that the agency doesn't have a rule that it can apply. And the statute says, very plainly, the most common sense result of that is just like in a contracts case. If the court were to find in a contracts case that the contract is void because it wasn't properly formed, the result is not you can apply it to whomever, just not the plaintiff standing there. It's not a thing anymore. And that's, to me, what the statute says. You set it aside because you haven't formed it properly and consistently with what Congress has said.
I certainly acknowledge that when a plaintiff is challenging the agency's decision-making, their legal theory could suggest that the agency regulation is invalid in all of its applications and as applied to other parties too. But I still think that in that case, just like in the case of interpreting a statute, the proper remedy is the party-specific relief.
But we don't have it. The APA is a different kind of claim. It's not the statutory claim is not about Congress's authority to make the policy decision. Did they follow the right procedures in making it? Let me ask you about 1252 F, because that's another basis that you sort of suggest that courts' authority is limited. When I look at 1252 F, it says that there's no jurisdiction or authority to enjoin or restrain the operations of the provisions of this subchapter, which seems to me as though Congress is prohibiting an injunction of the statute.
You've interpreted it, I think, to mean operation in the sense of any regulations, any policies of the government that are implementing that statute. But I guess I'm concerned about that because in E3, just the provision prior, Congress was very clear about spelling out things like regulations, guidelines, et cetera. I know that's a different provision because it applies to expedited removal, but Congress knows how to say when it's talking about claims being brought about guidelines, procedures, and things that the agency does. And yet in this statute, in F, which would, I think, also apply to E, it talks about the operations of the statute. So why isn't really what's going on here that Congress didn't want its new regulations, its new policies concerning immigration to themselves be enjoined, and it wasn't really talking about the agency's implementation in this provision?
So I think that that approach would be inconsistent with the court's decision last term in Alamán González, where the claims of the non-citizens in that case is that they were entitled to bond hearings under these provisions, and the court recognized that this bar prevents an injunction that would prevent the executive from implementing its policies with respect to bond under that statutory language. And so I think that the same argument potentially could have been made there, that that's not actually enjoining the statute, it's enjoining the agency's policies that are consistent with, in the agency's views, those statutory provisions.
All right, so what do we do about F as it applies to E? And again, I know E is not in this case, but if we're going to be interpreting F, is it your view that the limitation on injunctive relief, as you have interpreted it in F, applies to challenges on the validity of the system in E in the expedited removal context?
Yes, I think that we would take that position because as we understand this court's interpretation in Alamán González, it focuses on whether the claims in the case are premised on these statutory provisions and are seeking to require DHS to implement the covered INA provisions in a particular way. And so if the theory of the case were under 1226, any of its provisions, DHS is required to interpret the statute in a particular way or to take particular action. That comes within the bar that 1252 announces.
Then we have a statute here at E in which Congress has authorized very specifically a claim. Congress has said that you can bring a case in order to challenge a regulation, policy directive, written policy guideline, or written procedure of the Attorney General, or here DHS. Congress has allowed that, and you're suggesting that the only relief is declaratory relief under those circumstances, that you don't even have to follow, really?
So there is the opportunity for declaratory relief in any court. 1252F1 also permits coercive relief on behalf of individual non-citizens, and 1252F1 preserves this court's authority to enter any form of relief. So I think that those are the remedies that Congress delineated under these statutory provisions.
Thank you.
Thank you, counsel.
And so therefore, it's sort of analogous to mandatory pretrial detention statutes, where Congress says if you, as a prosecutor, determine that you're going to go after somebody, you're going to prosecute them in the criminal realm, there are certain people you have to detain during the prosecution. There are certain, people who've been convicted of certain crimes. We have statutes where Congress says those people have to be detained, but that doesn't speak to the antecedent determination of whether or not to prosecute those people. I think the problem that I'm seeing with the state's argument is that they appear to be conflating Congress's mandates with respect to detention and Congress's statements with respect to removal, and that the idea of 1226C is that once the determination has been made pursuant to prosecutorial discretion that you're going to remove someone, if those people fall into the particular criminal alien categories, they have to be detained for the purpose of that removal. Am I reading that correctly?
Yes. So the way that DHS has long understood and implemented this provision is that if we have a non-citizen in custody with pending removal proceedings, as 1226A requires, then if the non-citizen is described in 1226C, detention is mandatory. And the reason for that is not because it says shall detain. We don't think that that bare use of shall alone displaces enforcement discretion. It's because in 1226C2, Congress specifically delineated the permissible bases for release and said the Secretary Secretary may release only for narrow witness protection purposes.
And isn't it
language.
also related to sort of conceptions of government power? In other words, the reason why you have the authority to detain someone is because you've made the determination that they're going to be removed. The government doesn't just go around detaining people without having made a determination about their prosecutorial ability, without the fact that they're going to prosecute these people or they're going to remove these people. That's where the authority comes from.
Yes,
right?
And I think that this relates both to the colloquy that I was having with Justice Sotomayor and with Justice Kavanaugh. It would be a really extraordinary thing for Congress to have dictated to the executive that it has to seek out, identify, apprehend, and remove as an inflexible mandate each and every non-citizen who's described in a provision that uses the word shall in the INA.
Is that true? Why isn't the causal relationship, the chain, broken in the sense that you have voluntary decision-making by Texas, say in relation to the criminal justice costs, that you feel compelled or you want to go after individual people? In other words, aren't the costs associated with Texas's decision to incarcerate or parole certain non-citizens if the federal government decides not to detain them, aren't those a result of the state's own policy choices in a way, that we have recognized or decided is not sufficient in a case like Pennsylvania versus New Jersey?
Your Honor, I think ordinarily in the court's Article 3 standing analysis, for example, in the DACA case in Regents, the court didn't go, well, California is suffering this injury in the first place because they have chosen to employ individuals subject to this immigration right, et cetera. And so really, to some extent, the loss of these individuals is a self-inflicted injury. More to the point, Texas suffers injuries regardless of what it does, whether it detains, releases, or paroles individuals, because we have not only law enforcement costs, but social services costs and very serious threats of recidivism.
Well, all right, well, separate out can we just for a second separate out the criminal justice costs from the health care and other things that would be required? With respect to the criminal justice costs, presumably, first of all, the federal government has said that they've determined that these particular individuals aren't going to be a high risk, and so that's why they're not detaining them. So why isn't Texas's determination to detain them on Texas? I mean, presumably there'll be other states that might agree with the federal government and say, we're not going to expend any money to try to supervise or detain these particular individuals.
Well, 2 points, Your Honor. First of all, there are district court findings of fact. This was a disputed subject at the trial court regarding whether or not the rates of recidivism were acceptably high, what kinds of risk Texas was exposed to by these releases. And more to the point, Congress has made the determination, specifically in the passage of IIRA and 1226C, whether or not these individuals are unacceptably high.
Well, that's on the merits. That's the merits question. I mean, I guess my point is just in terms of injury and who is bearing the cost and why. Isn't it Texas's determination to go after and detain or keep detained these people, a cost that Texas has chosen to incur? The guidelines don't require states to keep these people in custody.
No, Your Honor, and I think that's because Texas is put to what we might call sort of an Article 3 dilemma, where it either pays the costs of continued detention or pays the costs that are incurred through recidivism. Again, recidivism in this case being a hotly contested question at trial, upon which there were direct testimony from one of the largest counties in Texas regarding the criminal population there, actual evidence of recidivism by specific individuals who had been detained and released pursuant to detainers.
All right, so can we answer Justice Sotomayor's question about net cost then? So fine, there might be costs with respect to this group of people, but the federal government says that you're going to save a whole lot based on other aspects of the operation of the guidelines. What's your response to that?
Two responses to that question. The first is somewhat straightforward, which is to say that's in the nature of a factual assertion about which the petitioners offered zero evidence whatsoever. That was a disputed fact question at trial. They offered no evidence. If there were in fact evidence, I think that would be powerful evidence attacking our standing. Their assertions afterward.
Yes, excuse me. Do you agree with me that the Elections Clause doesn't take any position as to who the entity in the state is that qualifies as the legislature?
We think the dissent in Arizona was correct, and that the legislature meant the legislature plus the gubernatorial veto.
Legislature defined by whom?
Well, I would point the court to Samuel Johnson's definition, where he said the three branches of the legislature.
So not the state constitution. That doesn't. I mean, I read the elections clause as essentially giving the entity, whoever it is, that is the legislature, the power to make this decision, but not taking a position as to who the legislature is.
And that is what the Arizona majority said, and we're perfectly content to abide by.
Okay, so if that's true, if it is the state's constitution that it tells us who the legislature is and whether what they're doing is a valid exercise of legislative authority, then I guess what I don't understand is why constitutional limits on the exercise of that entity, on its power, don't still apply, even in this context. So in other words, the elections clause says you get the right to make this decision. You have that policy determination. But the state constitution is the thing that gives this particular entity its authority to make any determinations. And the state constitution says things like, when you make a determination about things in your policy-making role, in the legislative power that we're giving you, you have to make sure that people are treated equally. You have to, whatever the constitutional provisions are that we say, that you're saying are so vague or whatnot, are limitations on that entity's legislative authority, not just in this area, but in every area, whenever they undertake to make a law. And so I guess what I'm trying to understand is, why are you suggesting that in the context of the elections clause, when this entity would ordinarily be bound by all of the limitations in the state constitution in its legislative authority role, why suddenly in this context do you say, no, 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 all those other constitutional provisions that would bind or constrict legislative authority that the state gives you because you're the state legislature, right? Why do those evaporate in this world? I read it as though the state court is essentially saying our Constitution authorizes you to be the legislature only insofar as you act in accordance with our Constitution's tenets. And you haven't done that in this instance. Why am I wrong about sort of conceptualizing it in that way?
Because it's a federal function, and that's what Lesser teaches. So there was a constitutional prohibition on the Maryland legislature allowing women to vote. And
no, I'm asking, can I just, when you say federal function, I guess maybe that's where I'm getting hung up. I thought it was a determination, a delegation of, policy-making power in the sense of you get to make this decision. But the authority for that body, wherever it is, that's called the legislature, comes from the state. Because, that was my example about we have two different entities in the state fighting. Who's the legislature, right? It's what the Constitution of the state says that gives you the power, entity X, to be the one who is the legislature making this elections decision. If I'm right about that, then what is being delegated from the federal Constitution is not your power as a legislature. It is just delegating to you the decision about time, place, and manner, which is fine. But you have to do that consistent with the authority that you have as an entity to make legislative decisions. And that comes from the state constitution.
And U.S. term limits says that is not right.
All
But
right.
the premise of your question is not right.
All right.